if you had to describe what happened yesterday in federal court, Mark Allenbaugh, what would you say about it?
Well, she won on the guidelines calculation big time, but she didn't win when it came to the guideline sentence. She actually got a guideline sentence when most people get a significantly below guideline sentence.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey, everybody. It's Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona, helping us get set for sentencing today. My good friend, sentencing guidelines genius, Mark Allenbaugh. Welcome back, Mark Allenbaugh. How the hell are you?
Doing well, Doug. Thanks for having me.
Oh, it's good to see you, man. Today, so we're here on a Saturday morning. What a week it's been. There's a lot of stuff going on that is directly related to our gig as federal sentencing experts. And boy, oh boy, oh boy, what a week. So we had the special counsel announced for the former guy. We got the oath keeper juries out deliberating. By the way, we've done podcast episodes on both of those things. I'll put those links in the show notes, but we talked about possible outcomes for the Mar-a-Lago thing. We talked about possible outcomes for Stuart Rhodes and the Oath Keeper. So if you guys are interested in hearing about that, links in the show notes. But today we are here to talk about the real big story from Friday, which was the sentencing of Elizabeth Holmes in California in federal court. We are here today to talk about what went right, what went wrong, and what the future holds for Elizabeth Holmes. So I'm going to give you a big old snapshot of what we're going to talk about today. We're going to do our deep dive into the federal sentencing guidelines. Mark's going to tell us how all that shook out to sort of set the stage for what the sentencing ends up being. We're going to talk about narrative elements. In other words, what was the mitigation story and the aggravation story presented on each side, because this is just a battle of stories, and the one who tells the best one, the most compelling one, the truest one is going to win the day. And so we're going to look at that. We're going to look at some other aspects of the story that weren't told that we have questions about, and we're going to talk about what prison we're going, what the prison issues are. In other words, where she's going, and how much time she might end up actually serving off the sentence she might have. So, without further ado, can you give me like a snapshot, just like a one sentence takeaway regarding the guidelines? If you had to describe what happened yesterday in federal court, Mark Allenbaugh, what would you say about it?
Well, she won on the guidelines calculation big time, but she didn't win when it came to the guideline sentence. She actually got a guideline sentence when most people get a significantly below guideline sentence.
Okay, and for the record, and I'm not trying to shame you down to the bone, but I sort of, I guess I am. No, not really. But we all made predictions, and Mark, of course, is a sentencing statistics genius. And he has sentencingstats.com, shameless plug, but that's what he does all day. He looks at the numbers of what are the guidelines and what are people getting under these guidelines. And we know the guidelines are fundamentally broken, and a lot of times people are getting way less than the guidelines call for. So, Mark, what was your prediction for what she was going to get, and what was that based on?
Well, my prediction was 8 years based upon the statistics about what similarly situated people were getting. And that was also based upon a much higher guideline calculation than what she ended up receiving.
Wow.
This is why I'm very shocked by this sentence. It's much more severe or serious than I was expecting.
Mm-hmm. Mm-hmm. And I was sort of admittedly all over the boards with my predictions, but my last prediction was, I think 10 was what she was
Yes.
going to get.
Yes.
But again, that was based on a higher guideline as well. So even that entailed
Yeah.
a significant variation from the advisory guideline range. So talk
Right.
about, okay, so you said she won on the guidelines. How did she win
Yeah.
on the guidelines?
So what we're looking at here in the left column, this is what the probation office in the pre-sentence investigation report and the government calculated her guidelines to be. So the BOL means base offense level was 7. The loss they contended was over $550 million, which is over the top range of the guidelines. And once the loss is over $550 million, it doesn't matter if it's $1 billion or $2 billion or whatever it is. Everybody gets the same. It's a plus 30. So that's originally what they thought it was going to be.
Wow.
More than 10 victims. That was pretty obvious in all the investors. There was certainly more than 10 investors, so that wasn't surprising. The government was arguing for an enhancement for reckless endangerment or reckless risk of death or injury. And what their contention was that in making or trying to make this blood testing machine, and she didn't test it adequately, and she lied basically about how accurate it was. And so that people that relied on the outcomes of those tests, their lives potentially were in danger because either the test was telling them that they had some illness or disease that they really didn't have, or it was over telling them that they didn't have anything when in fact they did. So this is what the government was arguing, that she had that she deserved this enhancement as well. And as well as, and this was really surprising too, it wasn't surprising that the government was arguing for this, but it was surprising that the court didn't give it. And this was a 4-level enhancement, which is a significant enhancement for role in the offense. The government and the probation office argued that because she was the CEO of the company and she had been directing all of this fraudulent activity and telling her employees to basically assist her in covering up all the problems with the Edison, which was the blood testing unit, that she should get a role, a +4 enhancement for her organizational role in the offense, or her leadership role. What ended up happening is at sentencing, the court found, and this was surprising to me, I wasn't there at the sentencing, so I don't know exactly what the grounds were, but the court found that the loss was only about $100 million, which is significantly less than basically what all the parties were contemplating. And as far
Well,
as
let me, before you break down what the outcome was, just because,
Yes.
and there are people maybe listening and they don't see. So you kind of know, especially if you've been listening to these episodes, how the guidelines work. But started at base offense level, loss is the main driver. It ratchets these guidelines up by 30. These are just levels that give us the outcome of what the months are. So +2 for more than 10 victims. They wanted +2 for risk of harm. They wanted +4 for a role enhancement. That put the total offense level at level 45.
Right.
And if you go to this chart in the back of the guidelines book, it says, well, what does that translate to in the terms of the sentence that is the guidelines are recommending here?
Right.
And what was that?
So what the guidelines were recommending, well, first of all, the sentencing table only goes up to 43. So she was up at a 45. And the way the guidelines work is if you get a number over 43, you just treat it as a 43. And the guidelines, if you're at a level 43, the guidelines literally say life imprisonment.
Yeah.
But none of the offenses of conviction. She was convicted of 4 counts of wire fraud, and each count carries a 20-year statutory maximum. So, and none of them carry a life sentence. You can't be sentenced to life for wire fraud. But so the way the guidelines work in a kind of funky way, which I disagree with, by the way, this interpretation, but this is the way the courts follow it, that if the guidelines call for life and none of the statutes of conviction call for life, you just take the statutes, each statute of conviction, and you add up the statutory maximums. So if in this case, each statute had 20-year stat max, just add all those up. 4 times 20 is 80 years.
Yeah.
So the guideline sentence was 80 years or 960 months.
Wow. Okay, so she's literally the calculations made by the by the probation officer that go to the judge and that the government was fully on board with, literally
Yes.
have her off the charts,
Literally.
and calling for 80 years in prison for this, which
Correct.
is obviously a life sentence for her.
Right.
So,
now,
okay.
Right.
Yeah.
Now, importantly, though, the probation office didn't suggest that the court, or wasn't recommending a guideline sentence for her. The probation office was recommending a 9-year sentence for her, or 108 months, and the government was recommending 15-year sentence, or 180 months. But so both those sentences, technically speaking, or both those recommendations were significant downward variances.
Which I will say is rare, I think, in our experience, to say both the PO and the government looked at these guidelines and just patently say, well, that's ridiculous.
Right.
And we are not going to recommend anything close to what these guidelines say. So fundamentally, I think that's a lesson on how broken and dysfunctional those guidelines are.
Yes.
But it is rare. I think it bears noting that it is rare to get the prosecution and the probation office on board saying, no, that's way too much.
Right.
So, okay. And but ultimately the judge makes these final findings on what enhancements apply and what the guidelines should be. So what happened?
So what ended up happening, and again, this was really surprising, is the court found that the loss amount was only in the neighborhood of $100 million. I say only. That's still a lot of loss, but it was a lot less than what both the government and the probation office had found, and what the SEC had claimed in the civil suit. And we were talking, close to $1 billion in loss. But the judge found, for a variety of reasons that I'm not really privy to yet, that the loss amount was only around $100 million. So that lowered that particular calculation from 30 down to 24. So right there, it saved her 6 offense levels in the court's loss amount. The court did agree that there were more than 10 victims, and that was kind of a no-brainer. The court didn't agree that there was didn't agree that the enhancement for reckless disregard for life or safety applied, and that was somewhat surprising. And from what I understand, a couple of the counts of conviction, the government was arguing that this applied, even though a couple of counts of her convictions, or a couple of the counts that she was tried for, she was acquitted of, and those particular counts pertain to her reckless disregard. In other words, the jury acquitted her of any conduct that involved the reckless disregard of her patients, or of patient safety and well-being. But the government nonetheless was arguing that should apply under this weird theory that has permeated the guidelines since 1997, where the Supreme Court in Watts versus the United States held that even acquitted conduct can be used by courts to enhance a sentence. And this is what the government was pushing on the court yesterday. But the court, to its credit, didn't buy it. Now, I'm not exactly sure if the court didn't buy it because it didn't believe that there was a preponderance of the evidence to prove it, because that's all you need to prove to get a sentencing enhancement at sentencing is a fact by a preponderance of the evidence and not beyond a reasonable doubt. Or because the court does disagree with this weird thing that's been permeating the federal sentencing law for the last 30 years, this use of acquitted conduct at sentencing. So regardless of the reason why, the court ultimately said, no, I'm not going to apply that enhancement.
Well, and let's put a finer point on that, which is to say, you lost, government. The jury, you didn't get that conviction, but yet you still get to argue it at sentencing. So it feels fundamentally icky there, but it's because of what you said. It's a different burden of proof. But it does bear noting that this is an issue that's kind of rearing its head a lot. And isn't there a pending Supreme Court case where this issue might get resolved?
Well, there are several. There's about 4 cases pending cert right now in front of the Supreme Court. In other words, 4 defendants are asking the Supreme Court to review this specific issue about whether acquitted conduct can be used at sentencing still. And also Congress is looking to pass legislation to preclude the use of acquitted conduct at sentencing. And the Sentencing Commission itself just recently, just last month or 2 months ago, announced that it's going to be looking at this as a priority now about whether to amend the sentencing guidelines to include the use of acquitted conduct.
Yeah, it is. It's such stark contrast to the presumption of innocence.
Yes.
And so that's interesting, and I'll be interested. I don't know if the sentencing transcript will reveal more of the judge's thinking on that, why he didn't give that enhancement, but that would be good to know.
Yeah. Yes.
But anyway, sorry to interrupt. Go ahead.
No problem. And then the last one this was the most surprising to me, is the enhancement for role in the offense. Pretty much any time a defendant, the way this enhancement works is if you're involved in a conspiracy, or you're involved in criminal conduct that involves others, and you're directing them in terms of what to do, like let's say you're the CEO of a company, where you're directing others on how to behave and what to do and blah, 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 blah. You get this enhancement, and you can get it. There's basically 3 levels to it. You can either get it if you're just an organizer, you would get +2. If you're at management level, you get a +3. And then if you're a leader, like she was, CEO, you would get a +4. But what was interesting here is that the court said, and I've never heard this before, the court said that this enhancement is primarily used in drug trafficking cases, where you're talking about somebody that's an organizer or a leader of an inherently illegal activity or an illegal organization, like a drug trafficking organization or the mafia or something like that, or a gang, not for legitimate corporations. And I've never seen that happen before, because many white collar offenders that are CEOs get this enhancement because they are in the exact same position as Elizabeth. They were CEOs of a company, and they direct others. And from what I understand, she had been directing other employees to engage in this conduct and help her hide the fact that the Edison wasn't working or didn't work as specified from other investors. So this shocked me, that the court, and I think she, forgive the term, but she really dodged a bullet here in not getting this enhancement.
Well, and I've never heard of such a thing either. I guess there's 2 ways you could look at this. Maybe this is a realization that this is the crime, that none of this happens but for the fact that she is the CEO, and it's really that is the other stuff that she did. So it's just piling on it. To me, it almost, the analogy is kind of like in our child pornography offenses, the use of computer enhancement. It's like, you can't do this offense pretty much without using a computer. And she couldn't do this crime but for the fact that she was a CEO. But the other way to look at this, Mark, is that the ultimate calculation is sort of a utilitarian view of the guidelines, in a sense of, I don't know if that's the right word to use, but just this idea that the judge has a number in their head and that they want to impose what the sentence is going to be. But if they find these enhancements, they're going to have to do serious deviation from the guidelines. And what message does that send to the public, that, oh, the guidelines were this and she got something so less serious, she got a slap on the wrist and blah, blah, blah. So that if the judge can basically manipulate the outcome of the guidelines by finding this or not finding that, then the judge gets to the final range, which is a now drop from a 45 to a level 33. Now we're at 135 to 168 months. Now the judge gets to give with a low end sentence. He gave 135, right?
Right. Yeah. The judge gave 135 months here, which is the low end of the guideline range as calculated. And you're right. I mean, to take a cynical view, if the court here already had a number in mind and kind of wanted to make this not bulletproof, but almost appeal proof, at least the sentencing part, this was the way to do it. Now, of course, the guideline calculation, if the government wanted to appeal the sentence, it can. But now the government's going to have to prove that these factors that the court did not find, these particular enhancements were wrong as a matter of law, or that the court applied the wrong standard. But also, more importantly, that the sentence was somehow ultimately unreasonable. And as we know, a sentence within the guideline range, which this was, is presumed reasonable. Now, that makes it hard also for Elizabeth if and when she does decide to appeal the sentence too, because she's going to have to overcome this presumption of reasonableness, since this sentence was within the guideline range.
Yeah, and she got huge breaks on the calculations.
And she got huge breaks. Yes, I mean that's the other thing too, is she got huge break. But the court isn't going to take that into consideration. I think it would have been one thing. It would have been arguably easier for the government to win, and even harder for her to win on sentencing. But it would be easier for the government to get a sentence overturned if the court had found that the guidelines were at 43, called for 960 months, but decided to vary all the way down to 135 months. That may have been an easier way for. It would have made it that sentence more vulnerable to being overturned on appeal, because as the courts have always said, the bigger the variance, the more justification you're going to have to give. And in here, that's not necessary now.
So when we started talking about this, and you had you predicted 8 years, that was based on the higher guideline calculation.
Yes.
So did you go back and do another statistical analysis of what people were getting under the level 33 calculation?
Well, I'm glad you asked that.
Nice.
A perfect segue.
Okay, good.
Let's see. Now, can you see this, or do I have to reshare the screen?
Yeah, I can see.
So this is what I did here is I did a calculation this morning based off what the government or what the court found for guideline sentence to be. So this is nationwide over the last 5 years, everybody that was matching Elizabeth Holmes guideline calculation. So sentenced under 2B 1.1, which is the fraud guideline, total offense level of 33, which is what the court found, criminal history category 1, and she had no criminal history, not subject to any mandatory minimum or consecutive sentence, and did not receive a government motion for like a 5K or a downward departure for any reason. And there were 60 of those cases over the last 5 years. And obviously that's not a lot, but we're still talking cases that involved hundreds of or tens of millions of dollars of loss. So they're not that many. And so what this chart shows, this is a box plot, and it's what the commission uses to illustrate the distribution of sentences. So that little X there in the middle shows that the average sentence for these people was only 93.1 months, and the median sentence was 98.5 months. What the median means is that half of the 60 had a sentence above 98.5 months, and the other half had a sentence at 98.5 months or below. The top of this box, what it illustrates is what's called the third quartile, meaning 75% of all defendants in this group of the 60 received a sentence of 135 months or less. And as we said, the 135 months is what Elizabeth got, and it's also the bottom of the guideline range. So what this shows is, in reality, over the last 5 years, people that were similarly situated to Elizabeth with the same guidelines calculations, 3 out of 4 of them received a below guideline sentence, and nobody received an above guideline sentence. The top of the guidelines was 168 months, and that was the highest sentence that was imposed nationwide.
Interesting.
So she did not, even though she won, like I was saying before, she won on the guidelines calculation. Going from a 43 to a 33 was huge for her, but she didn't win when it came to imposing the actual sentence in that similarly situated people receive, because someone that was similarly situated to her with a guideline calculation of 33 generally got a significantly less sentence, lower sentence than what she received. So she still got dinged. This was not a light sentence.
Yeah. Okay, so before we move off of the guidelines, did we miss anything that you wanted to talk about there? Because next we're going to talk about the story, but I want
Yeah.
to make sure we covered. It sounds like we covered it, but
Yeah, yeah,
anything
no,
else?
no, that's
Okay.
the only thing I would say is, at 135 months, what she would actually end up doing is, she would only do maybe about 108 months or 109 months inside, and that's taking into account the customary 15% off that you
Yeah.
receive for good conduct time. And
Yeah.
then generally inmates spend the last 6 months of their sentence on home confinement.
Yeah.
The First Step Act has provided now inmates with the opportunity to engage in recidivism reduction programming.
Yeah.
And what that stuff does is it allows you to earn credits 10 to 15 days for every 30 days of programming you go through. It gives you that 10 to 15 days that you can take off, not really take off the end of your sentence, but get transferred to home confinement earlier. So instead of getting transferred 6 months with 6 months remaining on your sentence to home confinement, you can increase that to, like, say, 8 months or even a year. The last year of your sentence, spend all of that on home confinement. So it's an effective way of reducing the
Yeah.
amount of time you're on the inside.
So yeah, so this 11 and a quarter years that she gets could end up being significantly less with
Yes.
good time credits, First Step Act credits,
Yeah.
and credit where credit is due. The First Step Act was something from the former guy's administration,
Yes.
and the
Yes.
BOP is still struggling on how to
Oh boy.
calculate
Yeah.
all of it. But
Yeah.
it is a good thing for anyone incarcerated in the federal system, and I'm sure that Ms. Holmes will be able to take advantage of that as well. And then
Yeah.
the last component there is this compassionate release, which
Yes.
tell me, what do you think, how if at all would that play into reducing her time spent in custody?
Well, compassionate release is the only mechanism available to inmates right now at the federal system to get out early, to literally get their sentence reduced and have a court take a second look at it. Generally, it's only available for elderly inmates or those that have already served a significant amount of time or a percentage of their sentence, or those that are really ill, and generally like with a terminal illness or something like that. Now, with the pandemic, courts have been granting it quite a bit, or at least a lot more frequently than they used to, granting compassionate release for those that are looking to that have, like, say, asthma or diabetes or some type of recognized risk for getting COVID-19. With respect to her, I don't think that compassionate release is really going to be a viable for her, at least now, because she's not scheduled to report until April of next year. And so she's going to have to start serving, at least a couple of years, I think, before that may be realistically available to her. Now, she can file any time, and she could file for as many compassionate release petitions as she'd like. But the chances of her getting out, she's young, she seems to be healthy. I'm not aware of any risk factors that she might have. I know she does have children now, but she does have a partner on the outside and parents to take care of the children. So there isn't that is one other factor sometimes that that judges will grant compassionate release, is if you have kids on the outside and there's nobody there to take care of them except you. And that's not the case for her children, luckily enough for them. So yeah, I think maybe in a few years that might be a better route for her.
Yeah.
If she's still in.
And so, as you mentioned, she has a self-surrender date, which means she gets to show up on her own to the facility where she's designated. And the judge did that, made it extra long. It's longer than normal. It's in April. Usually it's like 60 days on average that we see.
Right.
But it's because she's pregnant and it'll allow her to have her baby and bond with her baby. So that's nice. And I guess the only other hope for her is if she can convince the judge, like Steve Bannon convinced the judge, to stay the sentence pending appeal. And that rarely happens. It happened for Bannon, lucky man. But as we said, it's probably not going to be because she's got sentencing appeal issues, but I don't know if she has any good trial appeal issues that a judge might stay the sentence. But
well,
I'm guessing,
I mean, the court already denied her motion for a new trial based upon all the alleged error there. So it's doubtful that the court's going to find that there's a substantive issue for appeal.
Yeah. So she's likely headed to prison, barring any unforeseen circumstance, in April. All right. So this is, we're really halfway done, because what people, lawyers understand this, but what people may not understand is that sentencing is really a potent mix of the legal and the human. This is about not just judging the crime, but sentencing the person. And so the lawyers have this monumental task of doing the hard legal work. And I think the lawyers, as you correctly point out, did a phenomenal job attacking the legal/factual elements of the guidelines, and got those guidelines way down, and a huge win. But there's a whole other side to this, which is 3553. Which is the operative sentencing statute. Is why I call this studio 3553, because I'm clever. But the point is, that is a huge element of sentencing, which is what, help me understand the nature of and circumstances behind this offense. How did we end up in this moment? And help me understand the history and the characteristics of the person who committed the offense. Now, there are other elements of 3553, but those are the two biggies. And that is first and foremost about telling a powerful mitigation story. Battle of narrative. And so I wanted to shine the light on each side, and just kind of let's talk about where things went right or wrong with the story, because there was great legal work to get the guidelines down, but nobody, the rest of it is to get you below the guidelines, and that didn't happen here. So I know it's armchair quarterback, and it's easy to we weren't the lawyers, we have no clue about the things we don't know in terms of what was going on behind the scenes. So not to get too judgy, I'm sure there are a lot of moving pieces we have no clue about, but we do this a lot, and we know that storytelling is a function. So I thought the first place to start would be the sentencing memorandum that were filed. For people who don't quite understand the process, this is a big part of federal sentencing. Each side, government, defense, has an opportunity to file a sentencing memo, which really, it talks about guidelines, but it really is the first big attempt to lay out the story that you want the judge to understand, to help the judge make the right call at sentencing. And I want to share my screen, because I have both the government sentencing memo and the defense sentencing memo pulled up. And I just want to look at the opening paragraph of each memo, because, we're taught as lawyers primacy and recency. Start with a bang and end with a bang, because those are the things that are going to set the stage for your story, but also the things that stick with you, that you remember most and impact you. So I think when you're doing a sentencing memo, that opening paragraph is a really big deal. And so I'm going to start with the defense, because, I'm a defense lawyer, so why not? So here it is. I'm going to share this screen. Can you see this? I highlighted it.
Yes.
Okay. Preliminary statement. Elizabeth Holmes stands before the court having been convicted of conspiracy to commit wire fraud and 3 individual counts of wire fraud with respect to certain sophisticated investors in her company, Theranos. What are your thoughts on the first? Do you want me to just give you my thoughts, or do you? What?
Well, I mean, it's to your point about being impactful. I mean, this is to me, it's a little dry. I mean, I would think something a bit more flashy, especially for an 82-page sentencing memo.
Yeah, and with attachments, this sentencing memo that's filed is 1,013 pages.
Yeah,
which, I understand lawyers want to be thorough. I'm not sure a 1,000-page sentencing memo is the right call in a case. I don't know, but this case is unique. So, that's an unusually long memo with attachments. I have no doubt the judge read every page because federal judges are pretty darn good at being thorough. But anyway, here's my 2 cents. This is about an opportunity to take control of the narrative. There's something we call Shirley's Law that we talk about in the narrative gym and whatever, but it's very fundamentally simple concept, which is you have to take control of your story, because if you don't, someone else is going to tell your story for you and you're not going to like it. And what we did in this memo is start out with that's their story. It's been their story all along.
Yeah.
That's the crime.
Yeah.
And by the way, the judge sat through the trial. I'm pretty sure the judge knows what Ms. Holmes was convicted of. I'm pretty sure everybody on the planet knows about it. So what it is it's their story, and it's wasted space. I'm sorry to say. And then also a little nugget buried in there, which is with respect to certain sophisticated investors. And so what I believe is happening here is the stage is being set for a narrative that probably wasn't ultimately compelling at the end of the day, which is these people had it coming. They should have known better. They're sophisticated investors. And when you make investments, you take risks. And these people should have known there were risks, and shame on them. I mean, what else is the point of saying sophisticated investors? Now, there's a way to make that argument right. And I call it a relativity story. We have the 3 R's of sentencing stories that I always talk about. I call them revelation stories. How did we arrive at this moment? Not to excuse, but to give context to the crime. And relativity stories, comparing this to that. How is this different from that? And then my favorite are redemption stories. What have they done to make it right? And to show that they've learned and they're never going to do this again. So this sophisticated investor thing could be, if told correctly, a good relativity story, which is to say, these aren't like your, vulnerable victims that you're selling fake magazine subscriptions to and, bilking them out their life savings with zero intention of ever providing a good or a service that you're selling. Like, it's a very different kind of fraud. It is fraud. But it's a very different kind of fraud than those real fraudsters who are just there to scam you out of your money and nothing else. And that these victims are devastated as a result of the money that they've lost. But go ahead.
Right. Well, what I was going to say in that regard, what I do like about this paragraph, though, starts on line 9. The company achieved incredibly valuable inventions.
Yes.
What that is starting to set. And I almost would have started with that.
Yeah.
Because what this case is about, what makes her so different, is that unlike a Ponzi scheme or just a straight up fraudulent scheme where there is nothing, where people are investing, giving money to somebody, and then they just use that money to buy yachts and just live large.
Yeah.
She actually was doing stuff, and later in the sentencing memo, they go into detail about the patents, the hundreds of patents Theranos obtained, and the value of those patents, and how they had them independently assessed by other law firms to see what their licensing value is, and it's a lot, substantial. So they actually were creating stuff, even though the Edison ultimately didn't work. There was a lot of inventions around that, patented IP around that product that could still be valuable. And then the fact that, of course, down on line 13, that she never cashed out. She went down with the ship. And that also shows that she wasn't in this for greed or for herself, that she actually was trying to do good.
Yeah. I agree with you. I'm just sad that you had to say down on line 9 and down on line 13.
Yeah, right.
I think that there is a powerful story there, which is she set out to change the world. She believed she could do it. She assembled the brightest and best and sunk, as much of the resources that she had into doing it. Yeah. It really did move the ball further down the road to these amazing technological advances. She didn't get there. But really front loaded in that should be owning those mistakes. To say I had tunnel vision, I thought I could get there. I was in fake it till you make it mode, but ultimately I believed we were going to get there. And so it's basically doing all the wrong things, but fundamentally for the right reasons. And then maybe there's another story to be told about these choices that she's making, but I'm going to put a pin in that because I'm still on these opening paragraphs. So in second sentence, in sentencing her, the court's task is a heavy one. Again, I feel like this is wasted space. The court understands the gravity of the moment. And then what we have is a bunch of what I call and material. In other words, if you can add the words and then after each of these things, you're not shaping a narrative. You're not telling a story. You're just putting stuff out there. So, and she was young, and she was abused, and and she suffered trauma, and and then it ends this paragraph that there's no avoiding the scorn that accompanies Elizabeth Holmes. So again, it's sort of a victim narrative there. I think the argument is she's being punished in ways that are measured far beyond the time in custody. She has to carry this with her and this public nature of it. But on the other hand, she put herself in the public eye. She embraced being a public figure. And when public figures fall, there's public scorn, and that goes with the territory. So I did not find this 16-line opening paragraph with very long sentences and deflecting of blame, and like you said, the good stuff bearing the lead. I just knew I was going to be off to a rocky start there. I also knew it from the caption, which was motion for downward departure, which I think is an antiquated term. But anyway, that's my take on the government's memo. And I don't want to be hypercritical, but this is what I do. I'm a storyteller. These are the things that I look for. Now I'm going to share the government's first paragraph. Is that up still on the screen?
Yep, I see it. Yep.
Okay. So I highlighted the first two paragraphs, but really the first paragraph is six lines. 6-line paragraph versus the oh, by the way, as I scanned through this, I highlighted some of the citations in the defendant's memo. Let it not be lost on our dear listeners that one of the citations is Mark H. Allenbaugh, an article called Drawn from Nowhere, a review of the U.S. Sentencing Commission's white-collar sentencing guidelines and loss data. So congratulations, shout out to you. But anyway, 16. So the defense paragraph, opening paragraph was 16 lines. I believe that less is more in storytelling, and you got to get right to it. So let's compare their first line with the government's first line. Over the course of many years, Elizabeth Holmes defrauded dozens of investors of hundreds of millions of dollars. Time and again, she chose deceit over candor. So it's coming right out of the gate. We are going to tell you a story. This is fraud, pure and simple, any way you slice it. And she had choice after choice after choice where she could choose to do the right thing and tell the truth. And she chose deceit over candor. So right away, they're framing their narrative quite clearly. And they take us on that journey. And they give us a nice synopsis. She forged her own endorsements. She preyed on the hopes of investors that her young, dynamic entrepreneur had changed healthcare. She leveraged the credibility of her illustrious board. And through her deceit, she attained spectacular fame, adoration, and billions of dollars of wealth. That's pretty good opening salvo.
Yeah.
And then they kind of just amplify the pain in the next paragraph, which is when a journalist dares to ask questions about her achievement, she tries to dupe him and then attack him along with his sources. After her fraud was revealed, because we all know the cover-up's worse than the crime sometimes. After cover-up's revealed, she lied, obfuscated, and concealed. And at trial, she blamed her COO and longtime boyfriend, her board, her scientists, her business partners, her investors, her marketing firm, her attorneys, the media, everyone, that is, but herself.
Ouch.
ouch is right. And you see the difference. I mean, this is Shirley's Law. That is, they were very much in control over the narrative all the way through. And I think fundamentally that is why the judge didn't vary any more from that. She got a within guideline sentence when 3 out of 4 people in her shoes do not.
Right.
So, I guess they really kind of hit a lot of the mitigation notes, like abuse and things like that, but there was just no song. Like the melody was never clear, and
you were talking about the defense.
Yeah, I'm talking about the defense memo. I'll stop the share. And then, let's talk a bit about letters, because it is part and parcel of our work to submit character letters, mitigation letters from people in the community. Do you remember offhand how many they submitted in this case?
I think it was over 100.
Yeah. It was 130 letters. Now, in my district, in the District of Arizona, there's a local rule that limits the number of letters to 10. Which is a little extreme, but the takeaway from that rule is these letters, a lot of them say the same stuff. They're repetitive. They're not extremely powerful. They're not extremely useful to the judge. And once the judge has seen 10, they've probably seen it all. There's a way around that. You can quote from letters beyond if you want to in your sentencing memo, which the defense did put quotes from letters in the memo, which I think is a great technique to do that. But 130 letters, I didn't read them, but that feels like a lot. That feels like too much to me. What do you think?
I think it is too much. And for the reasons, and the problem is it can kind of dilute the impact of the better letters, because those are going to get lost in the judge's mind or the law clerk's mind or whoever's reviewing this, because there's so much to read. There's so much to compress here. And it's not like the court was given months to review this 1,000-page sentencing memo. It was just about a week or so.
Luckily, they have smart law clerks to maybe summarize, help them. But it's like a lawyer, a good lawyer who wants to do a good job sometimes believes that devastatingly thorough pleadings is the way to go. And I think less is more, always less is more. And even just some of the boilerplate language that was in this motion, they're citing the traditional like Booker and fan, or the guidelines are advisory kind of stuff, and this judge knows all that. It's not necessary, and that's why your submission's over 1,000 pages at the end of the day. It doesn't need to be that. It just doesn't need to be that. So what was the narrative here? What was the overarching narrative? Because like I said, I had a hard time wrapping my arms around it. Did you get a?
Well, I got the sense, I did get the sense, and I didn't read it word for word, but I read the bulk of it. But I got the sense that, like I was saying before, that Elizabeth wasn't your typical fraudster, and that this wasn't a Ponzi scheme. That she actually was creating something of value, that people, when they were investing, actually were investing in something and not just a complete sham. Like is often the case. And she wasn't living the high life. She wasn't cashing out, like, to her credit, that is what a lot of fraudsters will do, is they'll, once their stock value starts going up, they're cashing it and putting it in an offshore account and stuff like this. She didn't do that. So I think that helped. That was good.
I think the government counter is true. She's not cashing in her stock, but she is living in a beautiful, massive home. She's got an entourage. She's got bodyguards. She's projecting the image of this billionaire CEO and living that lifestyle. She's not kind of living in a trailer park on the edge of town.
Correct.
Getting this little startup off the ground.
Right.
So, but see, okay, so I'm going to veer into some wacky territory now, and just bear with me. And this is born either in a boy who cries wolf like fixation on autism spectrum disorder, or my personal narrative, which is I have someone I love in my family who's on the autism spectrum, and I've handled many, many, many cases, criminal cases, mostly federal criminal cases, where we have discovered that our client is on the autism spectrum. And what I have learned, and I'm guilty of this because autism's been around forever and we haven't known a whole lot about it until recently, which means every single one of us has had clients on the spectrum and we missed it. We didn't know about it. We didn't know what to look for. And we didn't know why it would matter, even if it was the case. And this has been nagging at me with Elizabeth Holmes forever. And part of my sort of why I'm a little reluctant to even go down the road is because I think when the lights really went on is when I watched the Hulu show about her, which is escaping me, but it was based on the podcast, which was done by pretty serious, credible reporters, and it was a very factually based podcast, and they made the Hulu series, and it was amazing.
Is it called The Dropout?
Yes, thank you.
Yeah.
The Dropout. And there were all of these telltale signs that I recognized from my own life experience, that Elizabeth Holmes could very well be on the autism spectrum. And there wasn't a word mentioned about it ever in her case. I don't know her life. I don't know her. I don't know her lawyers. I don't know if this was ever talked about or discussed, but, just going back from her early years, she was very awkward in her movements, her gait, they showed her running, and these are neurological, these are potential. Look at me, my armchair neuropsychoval. I'm not a medical person. I'm just a lawyer with a son on the spectrum. Okay. And then her inability to connect socially. She was so very awkward. She was hyper focused on specific areas of interest. She was brilliant in some areas, but had massive deficits in others. She worshipped Steve Jobs. Yeah. And I don't know if you know that her look, she's always in the black turtleneck.
Yes.
That is because
Steve Jobs. Yeah.
Steve Jobs. Yeah. And she, there are these scenes in the Hulu thing, and again, I don't know if they're based in real life or not, where she's actually standing in front of a mirror rehearsing social cues, social interaction, because she has such a difficult time connecting socially with human beings, which is the quintessential indicator of autism. And she's people who are on the spectrum learn to mimic. They learn to mask their social deficits by mimicking what other people are doing socially. And she's literally standing in front of a mirror practicing interacting before she's going out to a social event, a college party. And she's going to China, and she's learning Chinese. She's super focused on that. And then she's at Stanford, and she's brilliant in these science classes to where she's recognized as this kind of uber genius. But again, she's floundering in so many other areas of her life. And then there's this whole scene where she's up and running and she's the CEO, but can't play the part. She's kind of like blonde. She's looked like kind of ditzy and la and blonde. And these are the things Sunny Balwani's trying to instill in her. That the defense is saying, well, that's just abuse, that he's trying to abuse her into but no, he's helping her play the part. And there's another scene where she meets with a founder of, I can't remember who it is, on his yacht. And he's like, this is how a leader is. This is how you have to act. This is how you have to be. And she starts assuming these roles and mimicking what she believes a leader of a tech company, Silicon Valley, young, hip entrepreneur needs to be. And what is autism but hyper-focused tunnel vision on one thing? You start to lose all of the things around it, all of the morality, the ethical, the social. How is this going to impact the people that I'm dealing with? How are they going to feel about this? No, I don't care about any of it because I have my eyes on one thing, and that is the Edison, to the detriment of everything else around me. she's not even taking care of herself. She's not changing her clothes. You know, Sonny's saying, you got to drink this juice. You got to keep your energy up, your motive, hyper focus. And then, yeah, go ahead.
Well, you know, this just reminds me of one of the letters. This was the letter that her partner had written to the court, and he talks about her focus in there. And one of the things, this shocked me to read this, that she did, I think was within the last year. It's while she was pregnant. She decided to swim across the channel of the Golden Gate Bridge, and she had not ever competitively swam. She had not been swimming regularly since she was 14 years old. And she got it in her head that she wanted to swim across the channel. And by breaststroke.
Wow.
And she did it while she was pregnant.
Wow.
And he said in his letter, and I thought that was very bizarre.
Yeah.
I mean, why? It is a shark-infested water. She'd never done this before. Every time she was going to the beach all the time and swimming, constantly. We couldn't go on vacation, or if we went on vacation, I remember he wrote this. When we go on vacation together, it was to a beach. I would just be sitting there for hours by myself, watching this orange swim cap bobbing up and down in the water for hours.
Mm-hmm. Yeah.
I think this fits what you're saying.
It totally does. And I mean, look at Silicon Valley. All this tech is shaped by people on the spectrum who are genuinely often misunderstood and reviled because the social part of it is they're so bad at it. So look at Elon Musk right now.
Right.
He's being a colossal asshole on Twitter. And is that because he's just a bad person and just an asshole? I don't think so. I think he's admitted himself he's on the autism spectrum, and these are great people with great intentions, but they sometimes just act like assholes. And that, if that was the case,
maybe he's playing a part. Maybe that's the part he thinks he has to play.
It's possible. I mean, Zuckerberg, you know, same thing. Like, you could probably go down the list. People say Bill Gates is on the autism spectrum. So what these are people who are super high functioning in some areas and have terrible deficits, and others generally social deficits. So that, you know, while the government wants to say she's callous, you know, she thinks she's untouchable, she's playing, you know, she's spending all this money, but you know, there's if, and it's a huge if, I understand, but if that is what's going on here, that would have been a perfectly reasonable explanation for so much of her conduct that was wrong, that was fraudulent. And it wouldn't excuse it, but it would certainly put it in a very different light, in a very different context than that opening paragraph that the government said in their memo.
And it answers the why, and that's something that judges very often want to know. Why did the defendant engage in this conduct? Was it just greed? Was it that they're an evil person, or was it for some other reason? And I mean, I think that is the key to what judges think and how they're going to frame a sentence. I mean, if someone's just a greedy sociopath, that's going to have one type of sentence. But if there's some other reason that could be very mitigating, in fact, like this is just a personality disorder, or they're on the spectrum, then that's different.
Yeah. So it's just a thing we'll probably never know, but it's been in the back of my head forever, and I felt like it was worth talking about. So maybe my head is up my ass. I don't know, but I'm glad we talked about it.
Yeah.
But I think the takeaway is, even if it's not the case for Elizabeth Holmes, if you're a lawyer or if you're a client, if you're listening to this, you know, especially for girls don't get diagnosed with autism at the rate that boys do. And when Elizabeth Holmes was younger, I still don't think people were that aware. And so she wouldn't have necessarily gotten that diagnosis. There's also a constellation of other diagnoses that surround the nucleus of autism, which is anxiety, depression, ADHD, all these things that also help explain the why that you're talking about. But the takeaway is, I don't know if it's the case here, but it's been the case in your cases. If you've had one, I guarantee you've had a case where autism was an issue and you didn't know. And I don't blame you for not knowing. I didn't know until I knew. But I want people to understand that this, what is it? 1 in 8 people on the planet, something like that, are
Oh,
walking around.
wow.
Autism
I wasn't
spectrum.
aware of that. Yeah.
Maybe it's 1 in 50. I can't remember. 1 in 80. Maybe it's not that much, but a lot. So you're the statistics guy. You know that given the number of people that have it, that it's been in our cases and we've missed it. So keep your eyes out and understand when it is, what are the signs and symptoms, and then most importantly, why it matters to your mitigation narrative. And you're gonna
hopefully the Sam Bankman-Fried's attorneys are listening to this right now.
Oh yeah. That's gonna be our next big probably podcast. But he's at the front end of what's going to be a very long and arduous journey for him through likely through the criminal justice.
Yes, unfortunately.
Yeah. Yep. So we'll talk about that again. Always love having you on the podcast. You're welcome anytime and all the time. And
thank you, Doug.
I think, I don't know, did we cover it all? Are we good?
I think we're good.
All right. So if anybody's interested more about Mark Allenbaugh, go to www.sentencingstats.com and you can see his great work there, or just Google him, and like 6,000 articles, including the one that was cited in the Elizabeth Holmes defense memo, will probably be at your fingertips. But we have a lot to learn from you. Thank you so much. And I'll talk with you soon.
Okay. Thank you, Doug.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today, getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign out on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.